There are 6 forms that many American homeowners over 60 should strongly consider filing, but most never do. And without proper planning, those forms can significantly impact their children's inheritance of the house. I am going to walk you through every single one of them, the approximate dollar amount each one saves, and the order to file them in. The 5th form on this list is the one that 9 out of 10 seniors never even hear about until their family is already sitting in a probate court watching the judge decide who gets their parents' house. And we will get to that one in a few minutes. But first, you need to understand why this is happening at all. The American probate system follows procedures that many estate planning experts say prioritize court processes over family convenience. It generates substantial revenue for state courts and fees for the attorneys who work in them. Therefore, every single year, hundreds of thousands of American families lose tens of thousands of dollars, sometimes the entire value of the family home, because many people navigating the system never learned about the 6 documents that would have prevented it. Most of these forms cost less than $200 to file. Some are completely free, but if you do not know they exist, the system processes the money you would have left to your children, and there is nothing your family can do to stop it after you are gone. Here are the 6 forms in the order you need to file them. This first form is the difference between your children paying $20,000 or paying nothing. It is called a transfer on death deed, sometimes shortened to TOD. This document does one thing, but it is the single most important thing on this list. It allows you to name the person who will inherit your house the moment you die, without that house ever passing through probate court. Here is why that matters. The average probate case in the United States costs the family between 3 and 7% of the entire value of the estate. Therefore, on a home worth $300,000, your children will pay somewhere between $9,000 and $21,000 in court fees, attorney fees, and executor fees before they ever see the title to the house. But the money is not even the worst part. In some states, the probate process takes between 9 and 18 months to finish, during which the house cannot be sold, cannot be refinanced, and cannot even be cleaned out. Property taxes still come due. Insurance still has to be paid. The mortgage, if there is one, still has to be paid. All of that comes out of your children's pockets while they sit there and wait for a court to give them permission to access their own parents' house. A transfer on death deed eliminates the entire process. You file it once with your county recorder, and on the day you die, the house transfers directly to whoever you named on the form. There is no court involvement, no attorney fees, and no waiting period. The form is available in roughly 30 states. You can find out if your state allows it by searching for the words transfer on death deed and the name of your state. The filing fee in most counties is between $20 and $60, but the transfer on death deed only works if you actually file it before you die. Most people find this out too late. Therefore, this is not a document you can put off until next year. The second form is one that fewer people know about compared to other estate planning tools. It is called a ladybird deed. This one is only available in 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. If you live in any of those 5 states, pay very close attention to the next 60 seconds, because this single document can protect your home from a threat that impacts families every single day in this country. Here is what it does. A ladybird deed allows you to retain complete control of your home during your lifetime, including the right to sell it, refinance it, or rent it out. But the moment you die, the property automatically transfers to whoever you named on the deed. It functions almost identically to a transfer on death deed, except for one critical difference. A ladybird deed protects the house from Medicaid estate recovery. I covered the Medicaid 5-year look-back rule in another video on this channel, but here is the short version. If you ever apply for long-term care Medicaid in your final years, the federal government has the legal right to come back after your death and force the sale of your house to repay every dollar Medicaid spent on your care. On a typical nursing home stay of 3 years, that is somewhere between $240,000 and $360,000 the government can take from your estate. This is where families lose everything. The ladybird deed legally removes your home from your estate the instant you die. Therefore, there is nothing for the government to recover. Your children inherit the house free and clear, even if you spent the last 5 years of your life on Medicaid. But the ladybird deed has to be filed and recorded before you ever apply for Medicaid. If you wait, the look-back rule cancels the protection. Therefore, if you live in one of those 5 states and you own a home, this is a document you need to talk to an estate attorney about this month, not next year. By the time you need it, the window has already closed. The third document is the one that saves families more money than anything else on this list, but it is also the one where people make the most expensive mistake. It is called a revocable living trust. A trust costs more to set up than the first two documents, somewhere between $1,500 and $3,000, depending on the attorney. But here is why it is worth every dollar. When you put your home into a revocable living trust, the house no longer belongs to you on paper. It belongs to the trust. You still have full control. You can sell, refinance, or move at any time. Nothing about how you live changes. But because the house is technically owned by the trust, it does not belong to your estate when you die. Therefore, it cannot be touched by probate. On a $400,000 home, this single move saves your family between $12,000 and $28,000 in probate fees alone. But the trust does something even more important than that. A trust gives you specific instructions for how the house is handled after you are gone. If you have 3 children and one of them lives in the house and the other 2 want to sell, a trust can spell out exactly what happens. If you want the surviving spouse to live in the house for the rest of their life and only then have it passed to the children, a trust can do that. If you want to protect the house from a future divorce of one of your children, a trust can do that too. A will cannot do any of these things. A will gets read in a courtroom, and the judge decides what to do. A trust is private. It bypasses the court entirely, and it does exactly what you wrote into it. But here is where people destroy everything they just paid for. The most expensive mistake American families make with a trust is creating one and then forgetting to actually transfer the house into it. The legal term for this is funding the trust. If the trust exists on paper, but the deed to the house was never updated, the trust does nothing. The house still goes to probate. Every dollar you spent setting it up is gone. Therefore, when you set up a trust, the very next thing you do is file a new deed transferring the house from your name to the name of the trust. Skip that step and the trust is worthless. We are now halfway through the list, but the 5th document is still ahead, and that is the one almost nobody knows about. It is the one that will save your family the most, but it is also the one with the smallest window to act. Stay with me. The 4th document is an updated will with specific language about your house. If you die without a will in the United States, your state government decides who gets your property. The legal term for this is dying intestate, and the rules are not what most Americans think they are. In Texas, for example, if you die without a will and you are married, your surviving spouse only inherits 1/3 of your separate property. The other 2/3 go to your children, even if those children are from a previous marriage and have never spoken to your current spouse. In California, if you die without a will and you have children, your spouse only gets 1/3 or 1/2 of the community property, depending on the situation. In Pennsylvania, the first $30,000 goes to your spouse, and everything beyond that gets split. These intestate rules vary by state, but the pattern is the same in all 50. The state assumes it knows better than you do how your property should be divided. And unless you have a written will that says otherwise, the state wins every single time. The fix is simple. A basic will costs between $200 and $800 to draft with an attorney. Some online services do it for under $100. But if you own a home, I do not recommend the cheap online versions because the language about real estate has to be specific to the state you live in. But here's the part most people miss, and this is the part that tears families apart. A will must be updated every time something changes in your family. If you wrote your will in 1992 and you have not looked at it since, the names on it are probably wrong. Your spouse may have died. Your children may have divorced. Your grandchildren may have been born. The executor you named is probably no longer alive. Therefore, every will needs a review every 5 years. And every time a major life event happens, an out-of-date will is sometimes worse than no will at all because the family ends up in court fighting over which version controls. And while they fight, the house sits there, bleeding money. Now we are at the 5th document. This is the one I told you almost nobody knows about. It is called a durable power of attorney for finances. This is the form that 9 out of 10 seniors never file, and it is the one that costs their families the most. If you only file one document after watching this video, make it this one. Here is why. A durable power of attorney is the document that names someone you trust to handle your finances if you become unable to do it yourself, if you have a stroke, develop dementia, or end up in the hospital for an extended period. This is the document that lets your spouse or your child pay your bills, manage your bank accounts, and most importantly, handle anything related to your house. Without a durable power of attorney, your family cannot legally do any of those things. They cannot touch your accounts. They cannot pay your mortgage. They cannot do anything. They have to go to court and ask a judge to appoint a guardian or a conservator. The legal term for this is a guardianship proceeding, and the average cost in the United States is somewhere between $3,000 and $10,000 in legal fees just to get the appointment. After that, the guardian has to file annual reports with the court, which often costs another $2,000 to $4,000 per year. But the worst part is not the money. The worst part is the time. A guardianship proceeding takes between 3 and 6 months to complete in most states. During those months, nobody can pay your property taxes, nobody can sign for repairs to the house, nobody can sell the house if you need to move into care, nobody can do anything, and the bills do not stop. The mortgage company does not care that the family is waiting on a court. Therefore, families lose homes to foreclosure during guardianship proceedings every single year in this country, and a single piece of paper filed on a Tuesday afternoon would have prevented every one of those losses. A durable power of attorney costs between $100 and $300 to draft. It takes about an hour with an attorney. But here is the part that makes this so urgent. It has to be signed while you're still mentally competent to sign it. The moment a doctor questions your capacity, the window closes permanently. You cannot sign it from a hospital bed. Your children cannot sign it for you. Once that moment passes, the only path left is the courtroom. And by then, the damage is already done. The sixth and final document is your Homestead Exemption filing. This is the one that may be costing you money right now, today. Every single month, you do not have it. Almost every state in the country offers a Homestead Exemption to homeowners, but the rules and the savings are completely different in each one. In Florida, the exemption removes up to $50,000 from the assessed value of your home for property tax purposes. It also caps how much your property tax can increase each year, no matter how much your home value goes up. In Texas, as of 2024, the exemption removes $100,000 from the assessed value of your home for school district taxes alone. The annual savings vary by state, but for most senior homeowners, they range from $1,000 to $3,000 per year. Over 20 years of retirement, that is between $20,000 and $60,000 in your pocket instead of the state government. But here's what most seniors do not realize. In many states, the homestead exemption is not automatic. You have to file an application with your county tax assessor's office, and you only have to do it once. After that, the exemption stays in place for the rest of the time you own the house. The application is usually free, and it takes about 15 minutes to fill out. Many states also offer additional senior exemptions on top of the regular homestead exemption available the year you turn 65. These add another $5,000 to $15,000 in lifetime tax savings, depending on the state. Almost nobody who qualifies for the senior exemption actually files for it, because the county does not send you a letter telling you it exists. You have to know to ask, and now you know. Here's what you do this week. First, find the deed to your house. It is in your filing cabinet, your lockbox, or your county recorder online portal. Second, write down which of these 6 documents you already have and which ones you do not. Third, for any document you do not have, search the name of the document plus the name of your state. Read the first 3 results. Fourth, call an estate attorney in your county and ask for a 1-hour consultation specifically about home protection documents. The cost will be between $200 and $400. The attorney will tell you which of the 6 documents you actually need based on your state, your family situation, and the value of your house. Fifth, do not wait. Every one of these documents has a window, and every one of those windows closes the moment something happens to you. Once you are in the hospital, once the court gets involved, once the state steps in, none of these forms matter anymore.